Welcome to my channel. Sit back and listen to the best true crime stories. Let's go. The United States Federal Witness Protection Program is a program for the protection of witnesses who are at risk because of their involvement in criminal and judicial proceedings. Legislatively, this program is administered by the Department of Justice and practically executed by the U.S. Marshals Service. Several states such as California, Illinois, New York, and Texas have their own witness protection programs in addition to the federal government program. The program was officially launched in 1970. Its founder was Gerald Schur, who is still alive today. As a lawyer working for the Department of Justice in 1960, in a case against a New York organized crime leader named Francesi, he was confronted with the reluctance of witnesses to testify against him. He realized then that in some cases, the government should be able to give witnesses special protection. From that time to the present day, the Witness Protection Program in the United States has covered about 8,000 witnesses themselves and more than 11,000 of their family members. It should be understood that only those people whose testimony is invaluable to the success of the investigation and trial, who put the life of the witness or his or her family members in danger, are eligible for the program. The witness's determination to testify is also important. Before a person is admitted to the program, he or she must prove his or her determination to participate in the investigation and trial to the end, so that he or she cannot later refuse to testify. In the United States, there are 3 organizations involved in the WITSEC program. 1. The U.S. Marshals Service directly ensures the safety and health of non-custodial witnesses. 2. The U.S. Department of Justice manages the operations that take place. This primarily includes deciding whether to exit a witness out of the program, deciding whether the witness should enter the country, granting citizenship, etc. Witnesses who may fall under this program may be people whose testimony is directed against drug traffickers, terrorists, mafia, and members of organized crime groups. 3. Federal Bureau of Prisons executes the custody and protection of incarcerated witnesses. The last word in making key decisions in the Witness Protection Program always rests with the Office of the U.S. Attorney General. Only he has the authority to determine the specific cases in which a witness may be asked to enter the program. Situations in which a person and his or her family may qualify as a protected witness under federal law. Any crime involving racketeering and organized crime. Any drug trafficking offense. Any other serious federal criminal offense for which the witness may testify and because of which the life and health of the witness and his or her family are in danger. Any other offense that is similar in nature to those described above. Risk assessment. The process for a witness to enter the program is initiated when state or federal law enforcement agencies submit a witness protection application. It describes all reasonable and proven risks and threats, offers a choice of relocation sites, and assesses the risks. Resettlement risk is the risk to which the community of the area where the witness is proposed to be relocated may be exposed, since such witnesses are often criminals themselves. In general, statistics show that 95% of all witnesses entering the program are criminals in one way or another. Most often they are those who have been associated with organized crime. Then there is a preliminary interview of the witness with the marshals, during which he receives information about his new identity and lifestyle. If he agrees with all the suggestions, the next stage begins. Already the marshals evaluate the witness's determination and submit their recommendations to the prosecutor as to whether the witness can be placed in the Witness Protection Program. The final decision is made by the Attorney General of the United States, and only he. The Attorney General was given this authority under the Organized Crime Control Act beginning in 1970. This authority was then extended in 1984. Taking into account the advice received from the Marshals Service and from prosecutors, the Attorney General makes his own formal assessment of the risk of relocation of the witness and his family. The following factors are assessed in relation to each adult witness: whether the witness has a criminal history and criminal propensities, whether there are alternatives for the witness's protection. Consideration is given to whether it is possible to utilize the testimony of other potential participants in the investigative process. If the value of the witness's testimony outweighs the danger to the new community where the witness is to be relocated, the Attorney General renders a verdict of acceptance into the program. The witness and his or her family members then sign a memorandum of understanding confirming that they fully understand the rules of the program. The process is somewhat different if the witness is an inmate. Even if he or she is in federal prison, he or she may also qualify for inclusion in the Witness Protection Program if the situation in which he or she finds himself or herself meets certain criteria. In that case, the witness is required to take a polygraph test, and he or she may be denied protection depending on the results. Incarcerated witnesses are administered by the Federal Bureau of Prisons and often under the Protection Program are simply transferred to another prison for the remainder of their sentence. But entering the program is only the first step in making a witness disappear. Disappearance. The Witness Protection Program aims to create a new identity for a person at risk. Its goal is to help the witness adapt to a new life in which he or she will not be recognized by anyone. More than 300 million people live in the United States of America. The country has thousands of cities, and in each of them a witness can find a new life. Once a witness is accepted into the program, the U.S. Marshals Service creates a new identity for the witness and chooses a new place to live. This requires the coordination of many government agencies, and all these processes must take place quickly, smoothly, and in a state of complete secrecy. How a new residence is chosen. Most often, the witness is asked to name several places in the United States where he or she would like to live. Some say that they dreamed of visiting Hawaii, resting their bones on the beaches of Florida or California, while others dreamed of living in Nevada or Atlantic City all their lives. These are the very places the witness will name. He will never go on the program, because that means he may have voiced his wishes before in conversations with acquaintances. These are not good places to disappear. After the witness enters the program, at first the marshals immediately remove him and all his relatives from their previous place of residence. None of them will ever return there again. In the first stage, the witness lives for a period of time in a safe place that is temporary. Often these can be hotel rooms and inns. It is only then that he or she moves into what is known as a new life. It is worth considering that despite the creation of a new identity, the law enforcement agencies involved in hiding the witness retain all mention of his crimes, if any. Typically, the court marshal's office will notify law enforcement at the location of the witness's new life of his or her criminal history under various made-up pretexts. What is the responsibility of the marshals to conduct the witness's adjustment to the new location? Assist the witness with employment, find a place to live, provide the witness with a minimum living wage of at least $60,000 per year, create new identification documents for the witness and family members whose names are being changed for security purposes, provide the witness with medical care, ensure that the witness is provided with counseling by any specialists, including psychologists, psychiatrists, and social workers, if necessary. How personality changes. Participation in the program is completely voluntary. No one has the right to force a witness to participate in the program. By agreeing to such protection, a person realizes that his or her entire past life, including all ties, kinship, and acquaintances, is erased. From now on, he will never be able to return to his past way of life. His children will not see their grandparents. He will never be able to sit in a family circle with his brother or sister. His friends will disappear, remaining in the past. But, as the court marshals confirm, the incentive to stay alive for such witnesses is very strong, and rarely do any of them decide to leave the program. It is worth noting in particular that the program works for the witness only if he or she unconditionally follows the rules and obligations. At the slightest deviation from the instructions, the state washes its hands of the witness and leaves him or her to his or her fate. The principle works here. You either worry about the safety of yourself and your family, and we will help you to ensure that safety, or you take care of it yourself, which means that all responsibility lies with you. Usually the witness is offered several identities to choose from, and most often they are advised to keep their name, or at least their initials. Name changes are always done officially and legally, but only a very limited number of people have access to this information. Regular police officers, FBI agents, social workers, and other government employees do not have access to this information. Moreover, they are not even aware of the change of identity. Ensuring security as long as the witness may be in danger, the marshals provide him and his family with round-the-clock protection. The whole purpose of the Witness Protection Program is to keep the witness safe so that he or she can testify in court against members of organized crime, gangs, or terrorist organizations. Sometimes a witness and his family have to change dozens of residences before a court hearing before he can testify. And a witness is sometimes transported to court by helicopter, mail truck, or fishing boat. In one case, as a distraction, the marshals created a picture of a witness being transported to court in an armored car with a full escort, while the real witness arrived in a modest cab and entered the courthouse through a side door. Such measures are statistically very cost-effective. Since the program's inception in 1970, in 89% of cases witnesses have been protected and have given the required testimony in court. As a result of their testimony, more than 10,000 high-risk criminals have been convicted. A new life. One of the key tasks of the Witness Protection Program, as already mentioned, is to help assimilate the person to the new environment. Among other things, this requires assistance with employment. However, knowing that many of the witnesses are criminals themselves, the court marshals help, but do not solve for the witness his financial problems in the new place. In other words, the witness is given a rod, not a fish. Upon finding a new identity and a new home, the witness is required to work and establish his or her life on his or her own. They are given a little time for the process of full adaptation, and only during this time the state helps them with money. Thereafter, they are expected to become self-sufficient quickly, and any material assistance is discontinued. Only in cases of extreme necessity are witnesses carried around longer than usual. Again, it is worth understanding that participants in the Witness Protection Program receive money from the state only for living expenses. No one pays for their services as a witness. The funds allocated for each witness in the program are limited. The Department of Justice and the Marshals Service are sternly accountable for every penny spent. So the myth of spending an infinite amount of money per witness has no basis in fact. Once in a while, though, the program may pay for things that aren't exactly targeted, such as plastic surgery for participants, pension payments to the witness's elderly parents, and the creation of a credit history for the witness. But all of these are, for the most part, the exception, not the rule. The most important rule of the program is the stipulation that the witness cannot have contact with any relatives or acquaintances who are not in the program with them. They are forbidden to return to the places where they used to live. If this condition is not met, the witness is instantly out of the program. According to the official records of the U.S. Marshals Service, witnesses who have come under the protection program and followed the prescribed rules are extremely rare to be killed. Between the inception of the program and today, 19 such deaths are known. Each one of them always becomes a serious experience to avoid mistakes by the marshals in the future. Once the witness's adaptation to the new location is complete, he or she may have contact with representatives of the program no more than once a year, except when the witness decides to change his place of residence. This fact must be reported immediately. Recurrences. According to data released by the U.S. Department of Justice, about 17% of people who come under the Witness Protection Program go back on the road to crime. However, this is a fairly low percentage compared to regular criminals released from prison. Their recidivism rates hover around 40 to 50%. Digital technologies. Today, the Witness Protection Program faces the additional pressures of the digital age. Facebook, Google, smartphones, and social media, instant access to information via the internet pose new threats to court marshals. That's why they now employ hackers and programmers, computer technologists, and engineers of all kinds who can ensure the service of information security, hacking other people's servers, downloading databases, and other computer tricks.